Slip and fall injuries. Who is responsible? In order to prove a property owner is responsible for a slip and fall injury, we must prove that they were negligent. So what is negligence? Negligence is the failure to take reasonable care to avoid causing injury or loss to another person. In the context of a slip and fall, negligence can be established by proving the following four elements. Number one, duty. The property owner had a legal duty to act in a certain way towards the visitor. This means the property owner had the responsibility to keep their property reasonably safe for visitors. Number two, breach of duty. The property owner breached their duty by acting or failing to act in a certain way. That means the property owner failed to meet the required standard of conduct or care that is expected of them given the circumstance. Number three, causation. Property owner's actions or inactions directly cause the visitor's injury. This includes both actual and proximate cause. And number four, the visitor suffered damages as a result of the property owner's negligence. Now let's take a closer look at each of these elements. Number one, duty. The property owner has a duty to keep their property reasonably safe for visitors. That means the property owner should inspect their property regularly for hazards, warn visitors of known hazards, and maintain their property in a safe condition. For example, a property owner should inspect their property regularly for hazards such as wet floors, slippery surfaces, and broken stairs. Warn visitors of known hazards by posting signs or using cones to block off dangerous areas. Repair any hazards they find as soon as possible. And to keep their property clean and free of debris. Number two, breach of duty. The property owner breaches their duty when they fail to take reasonable care to keep their property safe for visitors. This can happen in any number of ways, such as failing to inspect their property regularly for hazards, failing to warn visitors of known hazards, failing to repair hazards they find, keeping their property dirty and cluttered. Number three, causation. The property owner's actions or inactions must have directly caused the injury in order for the property owner to be held liable. This means that the injured person's injury must have been a foreseeable consequence of the property owner's negligence. For example, if a property owner fails to clean up a spill and the visitor slips and falls on that spill, the property owner's negligence will be considered the cause of the visitor's injury. However, in that same example, if the owner fails to clean up a spill and the visitor is struck by lightning while walking into the store, well, getting struck by lightning is not caused by the spill. Number four, damages. An injured person must have suffered damages in order to recover compensation from the property owner. Damages can include medical expenses, lost wages, pain and suffering, and emotional distress. So for example, if a person slips and falls on a wet floor and breaks their arm, they can recover medical expenses, lost wages, pain and suffering, emotional expense. However, if they slip and fall on the wet floor and only suffer a bruise, they may not be able to recover any damages. In conclusion, in order to hold a property owner liable for a slip and fall injury, the injured person must prove the property owner was negligent, their negligence caused the injury, and the injured person suffered damages as a result. When someone is injured in a slip and fall, it is important to contact an attorney as soon as possible. An attorney can help the injured person gather evidence, negotiate on their behalf, file a lawsuit if necessary, and get that injured person the compensation they deserve. For many, slip and fall injuries are a source of frustration. Let the Marc Lopez law firm turn that frustration into compensation. Give us a call at 317-632-3642. Don't forget to like this video and subscribe to our channel for more information on the law of slip and fall.